Erwin. Welcome to the Hammer Museum. Thank you. I'm Claudia Besser. I'm the Director of Public Programs. Welcome to today's talk called We the People, a progressive reading of the Constitution for the 21st century with Erwin Chemerinsky and Devon Carbado. Today's talk seems incredibly important and incredibly timely. In what we all euphemistically call this political moment, it sometimes seems like the only thing holding this country together is the United States Constitution. But even that venerable document is constantly being challenged. Perhaps the most fundamental issue is the core democratic concept of one person, one vote, a concept challenged by gerrymandering, voter suppression, incompetent polling place management, a completely upside-down electoral college that results in voter disenfranchisement, and corporate money flooding the elections since the Supreme Court decided that corporations are people too. So as our beautiful American experiment feels very topsy-turvy right now, we have a new book giving a new reading of the Constitution and hopefully some guideposts that will help us move forward as a nation and get back to the work of the people. The book is called We the People, a progressive reading of the Constitution for the 21st century, written by Erwin Chemerinsky, one of the leading constitutional scholars. And after first describing the book and his ideas, Professor Chemerinsky will be joined for a discussion with UCLA Professor of Law Devon Carbado. After the discussion and the Q&A, we'll have copies of the book available for sale in the lobby. We'll also have coffee, tea, and cookies for everyone, so you can all talk to each other about the most important topics in the Constitution. And Professor Chemerinsky will be happy to sign them. So I'm going to give a brief introduction of each, and then we'll get to hear from them directly. Professor Devon Carbado is the UCLA Associate Vice Chancellor for Equity, Diversity, and Inclusion, and also a professor of law at UCLA School of Law, where he teaches constitutional law, constitutional criminal procedure, critical race theory, and criminal adjudication. Professor Carbado writes in the areas of employment discrimination, criminal procedure, constitutional law, and identity. He's the author of Acting White, Rethinking Race in Post-Racial America, and he's the editor of several volumes, including Race Law Stories and Time on Two Crosses, the collective writings of Bayard Rustin. Carbado graduated from Harvard Law School, where he was editor-in-chief of the Harvard Black Letter Law Journal. He joined the UCLA School of Law faculty in 1997 and has twice served as vice dean there. Currently, he's working on a series of articles on race, law, and police violence, and he serves on the board of the African American Policy Forum. Erwin Chemerinsky is the dean of the UC Berkeley School of Law. That was not intentional. His writings have appeared in the New York Times, the Los Angeles Times, the Washington Post, and the Boston Globe, among many other publications, and his many books include The Conservative Assault on the Constitution and The Case Against the Supreme Court. In 2017, National Jurist magazine again named him the most influential person in legal education in the United States. So without further ado, please join me in welcoming our esteemed guest speaker, Erwin Chemerinsky.
Thank you so much for the kind introduction and the warm welcome. Thank you for giving up some of your Sunday afternoon to be here. I want to thank the Hammer Museum for inviting me. I particularly want to thank Devon Carbado for giving up his Sunday afternoon to spend it with us and to talk about my book. Now more than ever, we need a progressive reading of the Constitution. We need a progressive interpretation of the Constitution to have a basis for criticizing what the Trump administration is doing and what the Roberts Court is doing. We need a progressive reading of the Constitution to provide a blueprint for the future. Let me talk a little about how I came to write this book and then tell you what its thesis is and give you a sense of how I developed that thesis. I'll be honest and tell you that I'd planned to write a very different book. I had written a proposal for what the Supreme Court should do after Hillary Clinton's election, when there would be 5 Democratic nominees on the Supreme Court. This was, in my view, a new era, and an era that was going to last a long time. Eras on the Supreme Court do last a long time. There was one era from the 1890s to 1936. This was a time of a very conservative Supreme Court. It declared unconstitutional over 200 federal, state, and local laws, especially those protecting workers and consumers. There was then an era on the Supreme Court from 1937 to 1969. During this time, there was always a majority of the justices appointed by Democratic presidents. The court became increasingly more liberal, especially in the 1960s, under the direction of Chief Justice Earl Warren. The next era on the court began in 1969, when Richard Nixon had 2 nominees for the Supreme Court confirmed, and then 2 more confirmed in 1971. From 1969 until February 13th, 2016, the day Justice Antonin Scalia died, there were always at least 5, and sometimes as many as 8 justices who were appointed by Republican presidents. But when Justice Scalia passed away, there were 4 justices appointed by Republican presidents and 4 appointed by Democratic presidents. If Hillary Clinton had been elected president, I assume she would have renominated Chief Judge Merrick Garland, or perhaps somebody even more progressive. And so I decided it was time to think about what a future would be, with a majority of the justices appointed by Democratic presidents. I wrote a book proposal and decided I wanted to begin it soon after the election. I had given it to my wonderful literary agent, Bonnie Nadell, and the day after the election, she wrote me back a short message saying, "It's scrap paper now." I waited about 6 weeks and then decided I wanted to write a book, but a very different book. The thesis of the book is what I began by saying, that it's more important than ever that we articulate, that we defend a progressive vision of the Constitution. Conservatives want to tell us that they can engage in, and that justices should practice, value-neutral judging. That's nonsense. The reality is that whoever the justices are on the Supreme Court are going to determine constitutional law. What the Supreme Court does affects all of us, often in the most intimate, the most important aspects of our lives. And I do think it's important at the outset to realize why the values, the ideology, the life experience of the justices determines the outcome in cases. When John Roberts went before the Senate Judiciary Committee for his confirmation hearings in the summer of 2005, when Brett Kavanaugh went before the Senate Judiciary Committee earlier this year, both said that they think that justices are just like umpires calling balls and strikes. That, too, is nonsense, because umpires just apply the rules. The Supreme Court justices make the rules. Supreme Court justices, as I want to talk about, constantly have to balance competing interests. Umpires never are supposed to be engaging in balancing in coming to their calls and decisions. The Constitution was intentionally written in broad, open-ended language. It uses phrases like cruel and unusual punishment, due process of law, no law respecting the establishment of religion. The Constitution couldn't possibly have survived if it had the detail of a statute. But it's a myth, a dangerous one, to believe that we can identify an original understanding of any of these provisions. So many people participated in the Constitutional Convention and the state ratifying conventions that it would be silly to say there was a single intent behind any provision. And even if it was possible to identify what the framers thought, they lived in a world so different from ours. In 1787, it was an agrarian slave society. In 1868, when the 14th Amendment was adopted, it was before the technology, before the issues we face in our modern society. Let me give you a couple of examples of this. Article 2 of the Constitution refers to the president and the vice president with the pronoun he. It's clear that the framers intended that the president and the vice president would be male. If we really had to follow the framers' intent, would that make it unconstitutional to elect a woman as president or vice president until the Constitution is amended? We'll take another example. The same Congress that ratified the 14th Amendment also voted to segregate the District of Columbia public schools. If we then look at the contemporaneous evidence of framers' intent, it's clear that they thought segregation was constitutional. That would make Brown versus Board of Education a wrong decision. any method of interpretation that makes Brown a wrong decision is clearly unacceptable. But perhaps most of all, justices have to engage in balancing. And that's, as I said, why value choices by the justices are inevitable. Virtually no constitutional rights are absolute. The government can infringe even the most basic rights. The government can engage in race discrimination if its action is necessary to achieve a compelling purpose. But what's a compelling purpose? Take the very controversial issue of affirmative action. All 9 justices agree that that the goal of affirmative action is diversity in the classroom. But the liberal justices believe that diversity is a compelling interest. The conservative justices reject diversity as a compelling interest. That's about the value choices that they're making. Or I can give you other examples as well, where it inevitably comes down to a judgment, a value judgment. Take the issue of same-sex marriage. In 2015, the Supreme Court faced the question of whether the laws that prohibit same-sex marriage deny equal protection. There's, of course, no question that laws that deny same-sex marriage are discriminating against gays and lesbians. Opposite couples can marry, but under these statutes, same-sex couples could not marry. At the very least, when the government discriminates on any ground, it has to have what the Supreme Court refers to as a legitimate government interest. Does a state have a legitimate interest in denying same-sex couples the right to marry? I think the Supreme Court appropriately and rightly answered that question by striking down such statutes. My point here, though, is that involves a value choice. Constitutional law is always about value choices. How those choices are made is so much a function of who are the justices sitting on the bench. The reason Republicans fought so hard to get Brett Kavanaugh confirmed, the reason why they did so even in the face of Christine Blasey Ford's uncontradicted testimony, the reason they did so even in the face of Brett Kavanaugh's stunning lack of judicial temperament, was they understand this, even while they profess that it's something different. They understand that constitutional law is a function of who's in those robes, who's making the decisions. This isn't new. It's always been that way. It always will be that way, because judging is an inherently human enterprise. So then it seems to me what we've got to start with is, well, what are the values the Constitution is meant to accomplish? And one thing that I realized in deciding to write this book is that the place to start is with the first words of the Constitution, the preamble to the Constitution. I've been a law professor for 39 years now. Until I began writing this book, I never focused on the preamble in my constitutional law course. I've got a constitutional law casebook, constitutional law treatise, and they say virtually nothing about the preamble to the Constitution. Many of us, if we grew up in this country, had to memorize the preamble, maybe in an 8th grade civics or history class. But I doubt we thought about it since. And yet, if you look carefully at the preamble, it tells us the values that the Constitution is meant to achieve. It tells us that one of those values is democratic governance. The preamble begins with the words, "We the people." That makes clear that this isn't going to be a monarchy, as was so common in the 18th century. It's not a situation where people assume power on account of inheriting it, but instead it's the people who are creating the Constitution. And if one looks carefully through the Constitution, and especially its amendments, so many of them are about creating democratic governance. Another value that you find in the Constitution is the desire to have effective governance. This too is stated in the preamble. And it should be obvious to us why this was a key goal of the Constitution. After the Revolutionary War was successfully fought, the United States was governed on the Articles of Confederation. The Articles of Confederation were a failure. There was a weak president. There was no federal judiciary. The Congress had relatively limited powers. It had no ability to adopt laws regulating behavior, no power to tax. Maybe most significantly, it didn't have the power to regulate commerce among the states. The result was that port states were charging a lot for landlocked states to get access to the water. Landlocked states were retaliating with tariffs. And a key inspiration for the Constitutional Convention of Philadelphia was to create effective governance. And the government created by the Constitution divides power horizontally, separation of powers among the branches of the federal government, and vertically between the federal government and the states. But always with the idea of creating effective governance while preventing tyranny. A third value that's found in the Constitution is establishing justice. It's clear that the Constitution, and especially the Bill of Rights, were about creating justice. And I want to focus especially on justice with regard to the criminal justice system. Some of the Fifth Amendment, all of the Sixth Amendment, and some of the text of the Constitution is about making sure that criminal defendants are treated in a just manner. In fact, the Constitution instructs us that justice has both a procedural dimension in terms of fairness of how people are treated, but also a substantive dimension in terms of wanting just and fair outcomes. There's a very famous passage from the Torah. If you ever visit me in my office, you'll see I have it framed on my wall that says, "Justice, justice thou shalt pursue." And I once heard a rabbi do a sermon that said, the reason the word justice is mentioned twice is it's meant to convey that justice has both a procedural dimension and a substantive dimension. The Magna Carta in England says this, and the United States Constitution expresses it. A fourth value that's found in the Preamble is securing liberty. The framers of the Constitution very much wanted to create a document that would preserve freedom. They were aware of the abuses under the King of England. Much of the Constitution was written in response to what they experienced. Take an easy example. The Third Amendment to the Constitution says that the government cannot require people to quarter soldiers in their homes. If we wrote a Constitution today, no one would think of including such a provision. But it was there because it was a response to the abuses that those who drafted the Constitution had endured. And so it was that when the states had considered ratifying the Constitution, many did so on the condition that a Bill of Rights would be added. And it was 10 amendments passed in 1791, the first 8 of those stating precious liberties that we possess. Now, those are the 4 values that you find if you read the preamble to the Constitution, but you'll notice one that's missing and one that should be added to this pantheon, and that's equality. It's not surprising that a document written in 1787 made no mention of equal protection. The Constitution very much protected and institutionalized slavery. It was a document that was written to protect the rights of white male property owners. Married women at the time were considered property, chattels of their husbands. Married women at the time couldn't enter into contracts in their own names. In 1868, after the Civil War, the 14th Amendment was ratified, and it does contain a provision that says that no state may deny any person equal protection of the law. The Supreme Court has long said that due process of law that applies to the federal government, the Fifth Amendment, includes a requirement for equal protection. And so these seem to me the 5 core values of the Constitution: democratic governance, effective governance, justice, liberty, and equality. And what I try in my book to do is offer a progressive vision for each of these values. Now, I recognize that we have a conservative Supreme Court now and likely the foreseeable future. Conservatives, though, realized long ago, when they saw themselves in exile, that it was important for them to put forward their conservative vision and then work to achieve it for the day that there would be 5 staunch conservatives on the Supreme Court. Progressives now need to do the exact same thing. And so what I'm trying to do in this book is take each of these values and suggest what a progressive vision might be. Let me give you some examples of this. In terms of democratic governance, I point to several problems in the book. One of them is the Electoral College. The United States is the only country in the world that describes itself as a democracy where the loser of the popular vote can become president of the United States. It's happened twice in the last 16 years. 2 of the last 3 presidents lost the popular vote, but nonetheless became president. 5 times it's happened in American history. It is impossible to reconcile any notion of democracy with the Electoral College. It's often forgotten that the Electoral College was created based on a distrust of the people. Alexander Hamilton, who we're now very much venerating, expressed at the Constitutional Convention that the people can't be trusted to choose the president, and thus we need the Electoral College. It's also often forgotten that the Electoral College was created so as to protect slave states. This was expressly stated at the Constitutional Convention. If the president was chosen solely on the basis of popular vote, then southern states with slaves saw themselves at a disadvantage. Slaves obviously didn't get to vote. One of the compromises in the Constitution was that in allocating representatives for the United States House of Representatives, slaves would count as 3/5 of a person. So southern states got a benefit from their slave population in the allocation of representatives. In the Electoral College, under the Constitution, a state's representatives are determined by adding its senators together with its representatives in the House of Representatives. By doing it this way, southern states get the benefit of their slave population in the votes for president. Despite this unsavory history that makes us all deeply uncomfortable with the Electoral College, it persists and it's unlikely to be changed. Amending the Constitution takes 2/3 of both houses of Congress and 3/4 of the states. There's no way the southern states are going to ever approve a constitutional amendment that decreases their power. I'd make the argument that the Electoral College is itself unconstitutional. Now, you might wonder, how could a part of the Constitution be unconstitutional? The answer is the amendments to the Constitution. Amendments modify the text. The text protects slavery, but the 13th Amendment outlaws slavery. The text says that a state can be sued by citizens of another state, but the 11th Amendment struck that out by saying a state can't be sued by citizens of another state. I would argue that equal protection, which comes to the Constitution via amendment, modifies the text and makes the Electoral College unconstitutional. But I don't even need to go that far. I think there's a simpler way to get almost that far, and that's courts can declare winner-take-all unconstitutional. In 48 of 50 states, all but Maine and Nebraska, the winner of the popular vote gets all of that state's votes in the Electoral College. If you voted for Donald Trump in California, your vote was meaningless. If you voted for Hillary Clinton in Texas, your vote was meaningless because of winner-take-all. There's a lawsuit now pending arguing that winner-take-all is unconstitutional because it disenfranchises people. Winner-take-all is unconstitutional because it violates the principle of one person, one vote. If winner-take-all declared unconstitutional, it would tremendously decrease the likelihood that we would have a president who lost the popular vote becoming president of the United States. A second value that I identify is effective governance. And here in the book, I talk about separation of powers and federalism, the division of powers among the branches of the federal government, the division of powers between the federal government and the states. With regard to separation of powers, I think the framers of the Constitution had a simple, elegant vision, and is one we should adhere to and one we should insist upon. And that's for any major action of government, 2 branches of government should have to be involved. It should take 2 branches of government to do anything that affects people in their lives. Take two branches of government to do anything that affects the future of the country. Just think about some of the things in the Constitution that illustrate this. To adopt a law generally requires involvement of both Congress and the president. To appoint somebody to the Supreme Court or a federal judgeship or the cabinet requires that the president appoint, requires that there be confirmation by the Senate. To approve a treaty requires involvement of two branches of government. To go to war in the eyes of the framers requires both the president as commander-in-chief and Congress be involved by declaring war. I think that we've had, under both Democratic and Republican presidents, an abandonment of this idea needing two branches of government for any major action of government. I think it's in this way that President Trump was able to adopt his infamous travel ban on his own, suspending immigration to the United States from foreign countries, something that the Supreme Court, I think, made a grave mistake in upholding on June 26th of this year. If there's to be a suspension of immigration, it should require actions of two branches of government. Even more troubling, President Trump was able to do this in violation of a federal statute. A 1965 Immigration and Nationality Act says that visas should not be denied to people on account of race, sex, religion, national origin, or country of residence. This was meant to get away from the country quotas with regard to immigration that condemned so many people to die in Europe during World War II. So if the Supreme Court had followed my vision, then the travel ban should be unconstitutional until and unless two branches of government approve it. Going to war should always require two branches of government to approve it. I think I can show you that since World War II, there's been a steady increase in the ability of the president to act unilaterally. And it's grown with each succeeding president. That seems to me inconsistent with the framers' vision, a vision that's meant to protect all of us. With regard to establishing justice, focus very much in the book on the criminal justice system. I talk about how people can be convicted, even sentenced to death with inadequate counsel. In Gideon versus Wainwright in 1963, immortalized in the book and the movie Gideon's Trumpet, the Supreme Court said anybody who faces a possible prison sentence has the right to an attorney. But this is what might be called an unfunded mandate. This is a situation where the Supreme Court has ordered it, but didn't ensure that it ever be funded. People get convicted, sentenced to death, with lawyers that you wouldn't want representing you if you had a traffic ticket. I argued a death penalty case in the Fourth Circuit in Richmond several years ago, where my client had at trial a lawyer who had never handled a criminal case, who local lawyers had told me you wouldn't want representing you if you were accused of having a traffic ticket. The United States Court of Appeals for the Fourth Circuit found that the lawyer's performance was egregiously poor, but said, oh, given the evidence, the jury would have convicted him and sentenced to death anyway, so therefore no relief. We need to have a better system of providing counsel for people who face prison, who face death. I argue at some length in the book that the United States should eliminate the death penalty. I truly believe that had Hillary Clinton become president, had there been a Democratic majority on the Supreme Court, finally the death penalty was declared cruel and unusual punishment. The death penalty is administered in a way that's tremendously racially discriminatory. The death penalty is administered in a way that's enormously arbitrary. In fact, just about a month ago, the Washington State Supreme Court declared its death penalty unconstitutional as being racially discriminatory and arbitrary, as violating the Washington State Constitution. The fourth value that I focus on in the book is about securing liberty. And I focus on some important examples here. I briefly mention one of them, and that's with regard to privacy. The Constitution doesn't mention the word privacy, but it's certainly reflected in so many of the provisions that are there. Justice Louis Brandeis, in Olmstead versus United States in 1928, very eloquently talked about how the right to be let alone is one of the most precious that we possess. The right to be let alone means many things. It limits how the government can search people, limits how the people can be arrested by the government. It limits how the government should be able to gather information about all of us and store information. And it also protects basic aspects of autonomy. For over a century, the Supreme Court has said that the right to privacy safeguards rights such as the right to marry, the right to procreate, the right to custody of one's children, the right to keep the family together, the right of parents to control the upbringing of their children, the right to purchase and use contraceptives, the right to abortion, the right to engage in private, consensual same-sex sexual activity, the right of competent adults to refuse medical treatment. All of these are rights that have been protected, appropriately so, even though they're not in the text. But I believe now that there are 5 justices on the court who will effectively or explicitly overrule Roe v. Wade. Since 2010, states have adopted over 400 new laws imposing restrictions on abortion. These have occurred in 33 different states. If the Supreme Court upholds these laws, it will effectively end the right to abortion in these states. But I think there are also likely 5 justices on the court who will vote to overrule Roe v. Wade. And I think it is essential that progressives explain why, under the Constitution, reproductive autonomy for women should be regarded as a fundamental right, why Roe v. Wade was correctly decided. The 5th and final value that I talk about in the book is equality. And I discuss many aspects of it. I talk about why courts should continue to uphold affirmative action programs, that given the long history of race discrimination, given its continuing reality, it's essential that there be programs, race-conscious programs, to achieve diversity, to remedy past discrimination. Here, too, I think that there are now 5 justices on the Supreme Court who will find all forms of affirmative action to be unconstitutional. This will have a devastating effect with regard to admissions at colleges and universities across the country, have a devastating effect with regard to equality in contracting, equality with regard to employment. I talk in the book about how progressives should urge that we interpret the Constitution to allow a finding of discrimination based on a racially disparate impact, or a disparate impact on the basis of sex. Right now, the Supreme Court says proving an equal protection violation requires showing a discriminatory intent. It's so hard to prove that government officials had a discriminatory purpose. It should be enough that we could show that the policies that are adopted have the effect of discriminating on the basis of race, the basis of sex. I intentionally conclude the book by dreaming. And I think in the longer term, what progressives should argue for is a right to minimum entitlements under the Constitution, that the Constitution should guarantee to each person adequate education, food, shelter, medical care. The Constitution promises us life, liberty, property that can't be deprived without due process of law. Now, today, in November 2018, this seems so far-fetched. And yet I honestly believe that had the Warren Court lasted just several years longer, it would have found the right to these minimum entitlements. It was in 1973, 4 years after the Warren Court, that the Supreme Court 5-4 held that there's no right to education under the Constitution. The 5 in that majority were the 4 Nixon appointees and an Eisenhower appointee, Potter Stewart. Surely the Warren Court had still been around in 1973, would have found a right to education. And others have argued that the Constitution should likewise be interpreted to create a right to food, right to shelter, right to medical care. And it was none other than Richard Nixon who considered in the early 1970s proposing such a guaranteed annual income for all Americans. A couple months ago, to the Brett Kavanaugh hearings, my law students were more despondent than I've ever seen law students being. And we had an assembly. I called it for Friday afternoon at lunch because that's when the room was available. And I worried about whether or not anybody would come. but the room was packed. Every seat was taken. Every space in the aisles and on the floor was filled with people sitting there. In fact, I had to begin by saying the favor I'd asked him was no one should call the fire marshals. And I asked 4 of my colleagues to join me in offering thoughts in the face of the Kavanaugh hearings. And it was my turn. The message that I wanted to deliver to my students was, though it seemed bleak right now, they really had just 2 choices. We all just have 2 choices: to give up or to fight harder. And I said, that really means we only have 1 choice. We have to fight harder and better than we ever have before. And I said, history smiles on the positions progressives have taken for a long period of time. The position that progressives have taken from the outset of the country have ultimately come to triumph. Over the course of United States history, there's been tremendous advances with regard to equality, base of race, sex, sexual orientation. Tremendous advances with regard to individual freedom. Now, it's not linear. It's not on a straight line. But I truly believe that the late Dr. Martin Luther King got it right when he said, the arc of the moral universe is long, and it bends towards justice. And so I wrote this book to try to describe how I want to see that arc of the moral universe bend, what justice will entail if only we as progressives articulate it and fight for it. Thank you.
So thank you very much, Erwin, for that terrific presentation. It was inspired and inspiring and just what the progressive doctor ordered, I'll presume to say. So I have to say, when I read your book and I came to the last word of the last line of the last page, I dropped the metaphorical mic. And that's a curious thing for me to do because I didn't actually write the book. Typically when one drops the mic, it's a moment of self-congratulation. But I felt compelled to do so in part because the book so embodies the title, We the People. And there are 2 senses in which it does that I want to sort of mark before carrying on. One is the mode of constitutional interpretation that you advocate for really centers we the people in a robust way. And the second, and this is crucial, you articulate complex constitutional ideas in a way that's truly accessible to the people. So I just wanted to say that loudly and clearly as a point of departure for where we will go. So we could start this conversation the way that Tina Turner starts Proud Mary, nice and easy. But I don't think we should do that. I think a lot's at stake, so we're going to rough it up a bit. And I thought I might do that by splitting our discussion in 2 parts. So first I want to talk about parts of constitutional law and democracy that are in the book, not necessarily salient in the book. This is not a critique. It's just there's so much you can do in one book. And then move more directly to some of the themes you take up. So here are the matters that I want to turn to in no particular order: judicial appointments, voter suppression, climate change, 5-4 splits, Roe v. Wade, which you just spoke to, capitalism and the Constitution. Now, you could spend an entire term on each of these, so we're going to kind of speed date our way through them, if you'll indulge me. So judicial appointments, I wondered about how you read the hearings, how you interpret them, how you made you feel. I mean, you commented on that just a little bit, but I want to say more about that. Were you thinking par for the course, disappointment, election has its consequences? So what are we to take away from that moment other than the important point, we need to fight harder?
Everything you said. Disappointment, elections and the Electoral College have consequences. I mean, we've got to go back just a little bit. I mean, what we saw in 2016 was unprecedented in American history. 24 times in American history, there was a vacancy in the last year of president's term. Yeah. In 21 of 24, the Senate confirmed. In 3, the Senate didn't confirm. But never before had the Senate said, no hearings, no vote on a presidential nominee for the Supreme Court. Merrick Garland's nomination languished longer than any nomination in American history. In light of that, it seemed clear to me that the Republicans were going to confirm whoever President Trump appointed. Once the revelations about Christine Blasey Ford became public, and once I listened to her on Thursday morning, I then for the first time thought, there's no way that the Republicans can confirm Brett Kavanaugh in light of that. This is why you don't want to listen to my predictions about anything. And then I listened to him that afternoon, and it was a stunning lack of judicial temperament. It was the most partisan I've ever seen a Supreme Court nominee. I counted 12 times that afternoon he said, "I like beer." This was essentially a job interview. Has anybody ever interviewed for a job before, talking about how much they like to drink? I have a Supreme Court argument coming the first week of January, and I'm going to resist my children's advice to put a can of Budweiser on counsel table.
Your children give very good advice.
So the answer is Republicans wanted this seat filled by a conservative, and they want it done substantially before the November midterm election, and they were going to do it no matter what.
So let's think about some of the no matter what. How are we to think about what those hearings suggest vis-a-vis where we are as a nation on the issue of sexual violence? Is it that that hearing is so exceptional, so politicized that we can't really draw general conclusions from it? Or does it say something about where we might still need to be on this important social problem?
It does say something about attitudes with regard to sexual violence. No one ever suggested any reason that Christine Blasey Ford was coming forward out of partisan motivations. Her testimony was compelling and truly believable. So yes, it says something about that. But I think it says something even more. The Republicans wanted this seat occupied by a staunch conservative, and it didn't matter what she said. It didn't matter that it was about sexual violence. They were going to vote to confirm him.
Fair enough. One more question on judicial appointments. Is it fair to say that whereas the Republicans have this as a serious project, Democrats have been wishy-washy on judicial appointments, and not just with respect to the Supreme Court. I'm talking about the idea that lower court judicial appointments are really important too, and they've not necessarily been a priority for Is that a fair statement?
Very much so. To start with the Supreme Court, and I point this out, I think, in the preface to the book, the number one reason given by Trump voters was the Supreme Court. 54% of Trump voters said that they voted for him on account of wanting him to fill vacancies on the Supreme Court. For those who voted for Hillary Clinton, it was number 4 on their list. Yeah. Democrats have never made this a priority in the way that Republicans have done so. But it's also that Democratic presidents haven't done so. Both Bill Clinton in his first years as president and Barack Obama in his first years as president let many vacancies on federal courts of appeals go unfilled. My wife has a close friend who was the White House staff secretary at the beginning of the Obama presidency and repeatedly said to her, "It's about judges." And her response was, "Our policy is we're just focusing on health care in the first 2 years. We're not going to do anything else." Well, the Republicans then were able to take the Senate and really limit who President Obama was able to pick for the federal courts of appeals. The Republicans shut down the process of confirming appellate nominees in the last 2 years of the Obama presidency. It meant that Donald Trump came into office with more vacancies to fill than any president in decades. So I think Republicans get the significance of judges much more than Democrats do, and we need to change that.
Amen. Voter suppression. Voter suppression. Can we all say voter suppression? I mean, there's a way in which it's another issue that Democrats were late getting to the table on voter suppression, quite frankly. I'm not quite sure why it's so unspeakable. Increasingly, it's become unspeakable, thank goodness. And against the backdrop of this electoral cycle, it's on the table. The question I want to ask is, how should we think about voter suppression with respect to constitutional democracy more generally? And are there avenues of contestation that we haven't really thought about and should?
I want to talk about the Supreme Court initially and then address the question more directly. One of the parts of the book where I talk about democracy is addressing a Supreme Court case, and I didn't talk about it from the podium, which I think is one of the worst decisions and one of the most important decisions of the Roberts Court. It's called Shelby County v. Holder from 2013. It involves the 1965 Voting Rights Act, which I think is the most important federal laws adopted in my lifetime. And Section 5 of that provision says, for jurisdictions that have a history of race discrimination in voting, they can only have significant change in their election system with permission of the Attorney General. And this provision was tremendously effective in keeping state and local governments from adopting voter suppression laws. The law was about to expire in 2007, and it was renewed for 25 years by a unanimous vote of the Senate, 98-0, and with only 33 no votes in the House, and it was signed into law by President George W. Bush. The Supreme Court in Shelby County versus Holder 5-4 declared these provisions unconstitutional. Chief Justice Roberts wrote, joined by the 4 conservative justices, he said that this violates the principle of equal state sovereignty in the Constitution, that Congress has to treat all states the same. I challenge anyone to find for me a provision in the Constitution that says that Congress has to treat all states the same. Now, you know from having just heard me, I don't believe that we can ever know the framers' intent or have to follow it if we know it. But if there's any place that's clear as to framers' intent, it's that the Congress that ratified the 14th Amendment didn't believe that Congress has to treat all states the same. That's the Congress that passed the Reconstruction Act that created military rule over southern states. Nonetheless, the Supreme Court declares this unconstitutional. Immediately, states like Texas and North Carolina put back into place laws that were very much about voter suppression that had been denied approval by the Attorney General. Voter suppression is a huge problem. You only have to read what was done to keep people from being able to vote in the state of Georgia. And I think Stacey Abrams is bringing a lawsuit about it now in federal court. The Secretary of State, who was running for governor against her, did all sorts of things in terms of closing polling places, denying electricity to polling places, and the like, to make it much harder for Democratic voters to be able to cast their ballot. We can't be a democracy if one side can rig the elections.
Fair enough. So I want to ask a question, but you have to promise that you will not say I'm terribly naive after I ask it. It's about 5-4 splits. So here's my question. Chief Justice Roberts, the next swing voter. So stay with me and don't throw any progressive eggs. Here's what I'm thinking. So there's a feminist line that goes, women are not born women, they become women. One might say that swing justices become swing justices, they're not born that way. Kennedy wasn't always a swing justice, it's fair to say. Chief Justice Roberts is a constitutional minimalist, one might say, is interested in the legitimacy of the court, is interested in his own legacy. He will want to check himself before he wrecks himself. So there's some investment in him doing the right thing. You couldn't wait to tell me I'm wrong. Carry on.
No, it's more complicated. I think in some areas that's going to happen, but in other areas it's not going to happen. I think there are some places where John Roberts is the conservative true believer, and he's going to follow conservative judicial ideology. In other areas, he may be more moderate. Let me give you my evidence of this and then tell you the areas where I don't think we're going to see a more moderate John Roberts. My evidence of this is the Supreme Court's decision on marriage equality, Obergefell versus Hodges, on June 26, 2015. It involved challenges to several state laws that prohibited same-sex marriage. I predicted publicly that John Roberts was going to be part of a 6-3 decision to strike down laws prohibiting same-sex marriage. And I said the same things that you just did. John Roberts wants to be on the right side of history. There's no doubt where history is going on this issue. And so he would be part of the majority. Not only was I wrong in did he dissent, but he wrote an angry, vitriolic dissent. The only dissent John Roberts has read from the bench since coming on the court in October 2005 was that in Obergefell versus Hodges. I think with regard to things like gay and lesbian rights, abortion rights, race and affirmative action, there's going to be no moderate John Roberts. I mean, you know his decision in a case called Parents Involved in Community Schools for Sale School Number 1, where he says that all forms of affirmative action are unconstitutional. It's where he uttered his famous line, the way to stop discriminating based on race is to stop discriminating based on race. We're not going to see a more moderate John Roberts with regard to affirmative action. And as I said, with regard to abortion, he's never voted to strike down any law regulating abortion. Not as an appellate judge, not as a Supreme Court justice. In other areas, I think we'll see Roberts trying to push the court in a more moderate direction, but not in those.
Fair enough. environmental justice. So we're obviously in a moment where in California we're dealing with tremendous devastation. Some of you might have experienced it, loss of lives, loss of property. I mean, it really is quite dreadful, and it raises a question about where the court is going to go on this issue. Climate change is one dimension of it, not the whole dimension of it. California in particular has been experimenting in interesting and novel ways with environmental regulation and the like. Will the Supreme Court cramp our California style in this respect? Will it limit other kind of moves in the direction of environmental justice from where you sit?
Climate change is something that really requires legislative and executive action. There's a limit to what the court can do to deal with the problem. And we're talking about here really a threat to the survival of the planet in a relatively short amount of time to deal with it. And we couldn't have a worse president or worse head of the EPA than we do now to deal with this. In 2007, in a case called Massachusetts versus Environmental Protection Agency, the Supreme Court said that the Environmental Protection Agency was required to deal with the problem of climate change. That was a 5-4 decision. It was written by Justice Stevens. The dissent was written by Chief Justice Roberts. I doubt there are still 5 justices who would say that the law requires that the government deal with the problem of climate change. There's a fascinating lawsuit right now. It was filed in federal district court in Oregon on behalf of children, and it argued that the United States government is violating what's called the public trust doctrine. The public trust doctrine says that the government holds all natural resources in trust for the people, and that the government's violating this by not dealing with the problems of climate change. The federal district court judge, Ann Aiken, refused to dismiss the case. The Ninth Circuit refused to dismiss the case. The Supreme Court refused to dismiss the case. It then has gone back to trial. They've gone back to the Supreme Court. It's back in the Federal Court of Appeals. But I'm very excited about that lawsuit, but I don't know what will happen when ultimately the Supreme Court gets to the merits. Now, what you raised specifically is California is trying more aggressively to deal with the problem of climate change. Governor Jerry Brown has taken this initiative. And the question is, will the Supreme Court find that the state is preempted, precluded by federal law in this regard? There's a great irony there. Throughout American history, it's been the conservatives who've been champions of states' rights. They championed states' rights as a way of trying to block the abolition of slavery. They championed states' rights in opposing Reconstruction. They championed states' rights when it came trying to oppose the New Deal. They championed states' rights in opposing the end of segregation. Wouldn't it be ironic now to see the conservatives trying to oppose states' rights in favor of federal power when states' rights are used for things like dealing with climate change?
So Roe v. Wade, you've essentially said dead, dead, dead. And you mean what you say.
I have no doubt that there are 5 justices who will either effectively or explicitly overrule Roe. Now, they can, as I say, effectively do it because 33 states adopted over 400 laws imposing restrictions on abortion. They just have to uphold those laws, and it will close the facilities in those states where abortions are performed. But I also think there are likely 5 justices who will say Roe was wrong and it will be overruled. We need to think about what the practical consequences of that will be. In California, abortion will remain legal. In about half the states, abortion will remain legal. But about half the states either already have laws on the book that prohibit abortion or will quickly adopt such laws. A couple of initiatives to do so passed just a couple of weeks ago on Election Day in November. The result of this will be that women with resources will still be able to get abortions by traveling to states where abortion is legal. Before New York became the first state in this country to legalize abortion, 40% of abortions in England were performed on American women. It wasn't poor women who were traveling to England for abortions. It's also teenagers who are much more likely to face the choice, the very cruel choice, between an unwanted pregnancy and an unsafe illegal abortion. But I think that we're within just a few years of, again, that being the reality. And those who remember what it was like before 1973 need to tell the story to the current generation who's always lived with the assumption that abortion was there.
So I want to ask a kind of fill-in-the-blank question that pertains to Roe again. So conservatives have employed Roe as a battle cry. It's done an awful lot of movement building on the ground. So if I were to ask you, blank case should be to progressives what Roe v. Wade is to conservatives, what would that case be for you?
Roe versus Wade.
Roe versus Wade.
Roe versus Wade should be the thing that should get people to go and to realize the importance of the Supreme Court. It's Roe versus Wade that should get people to realize how much the Supreme Court affects us in the most intimate, important aspects of our lives. That this is about a fundamental aspect of personhood and women being able to exercise their reproductive freedom. The majority of people in all the opinion polls favor that women should have the right to choose. And so I think that it's important that progressives not be defensive about this, but explain why autonomy is protected by the Constitution and why reproductive choice is a basic aspect of autonomy.
Fair enough. So I want to ask you about originalism. And you make a compelling case against originalism, which includes the idea that it doesn't deliver its promise, which is to say value-neutral constitutional interpretation. And I wonder whether you think that people who propound the idea that it's value-neutral constitutional interpretation, lawyers, judges, lay people, are they under a false consciousness or are they dishonest? Is there some other way to understand this? You're just duped or you're lying?
Even the conservatives on the Supreme Court who profess to be originalists abandon originalism when that serves their political goals. Let me give the example I mentioned earlier, Shelby County versus Holder. This principle that Congress has to treat all states the same. That can't be justified from an originalist perspective, but Justice Scalia and Thomas from the majority. Or the example I mentioned earlier, affirmative action. The same Congress that ratified the 14th Amendment also adopted so many programs that today we call affirmative action, things like the Freedmen's Bureau and the like. And so you'd think that if somebody was an originalist, they would say the original meaning of the 14th Amendment, its original understanding was to allow affirmative action. Yet you never find Justice Scalia and Thomas mentioning originalism when they say that all affirmative action is unconstitutional. Or let me look at it another way. Take Justice Scalia as an example. He believed that the First Amendment allows the government to give unlimited aid to parochial schools, allows the government to have unlimited presence of religion in government observances. He says that the First Amendment means that people should be able to discriminate on account of their religious beliefs. He believes there's no protection of abortion rights under the Constitution. He believes that affirmative action is unconstitutional and so on. Unless you believe that the 2016 Republican platform and the framers' intent were identical, you have to come to the conclusion he's simply reading his own values in the Constitution and pretending that it's supported by originalism. So in answer to your dichotomy, I would say it's just dishonest.
So staying with originalism just for a little while longer. So why, if everyone understands that originalism leads to Jim Crow, originalism leads to the subordination of women, originalism doesn't lead to gay rights, originalism anticipates, requires class inequality, why is it respectable?
People want to believe that there's law that exists apart from the people who are making the decisions. Don't you see this in law students all the time?
All the time.
They come believing that law is this brooding omnipresence that's out there, and the justices can in a mechanical way discover it and apply it. And originalism appeals to that notion. What Justice Scalia can say is, it doesn't matter what I believe. I'm just following the framers' intent. And that sounds so appealing. And you can have John Roberts and Brett Kavanaugh go for the Senate Judiciary and say, I'm just an umpire, my views don't matter. And so this doesn't sound partisan. Sonia Sotomayor went before the Senate Judiciary and said, judges just apply the law, they don't make the law. Roberts and Kavanaugh and Sotomayor should be ashamed of themselves for saying that, because it's such a false impression of what judges do. But it's an appealing impression of what judges do, And that's why I think it has such currency.
So I want to ask whether we should be trading on that currency in the following sense. So your book, your point of departure is to start at the very beginning, because it's a very good place to start, with the preamble of the Constitution. That's where you begin, and you say, look, there are values there that we should think hard about and internalize in our constitutional interpretation. Fair enough. That's an original document. Why, you say clearly that you're not making an originalist argument, and I want to say it's an originalist document. Why don't you take originalism away from the originalist? Why isn't this book about the true originalist interpretation of the Constitution? I mean, conservatives do a really good job of appropriating civil rights language. The right to work is actually a union-busting move. Reverse discrimination, you pick their turn of phrases, they all do work. And we seem to be struggling. So I'm saying, if it's the case that you're going to an original document, the preamble, why not call it some form of originalism?
It's some form of originalism in that all of the justices, liberal and conservative, believe they're interpreting a text. But originalism has a connotation because of how it's been used since the 1970s. And that's that the Constitution's meaning is fixed at the time it's adopted. It can be changed only by amendment. We would have to redefine originalism in order to be able to use it in a progressive way. And then I think what we're doing is fighting over the meaning of a word. And I don't think that's going to get us where we want to go.
So you don't think that, for example, civil rights initiatives, under which many conservative projects now travel, civil rights initiatives mean against gay rights. Civil rights initiatives mean against affirmative action. That there's some appropriative space for originalism. Or you might be saying it's too overdetermined. Forget it, let that one go.
I think that progressives need to be as good as conservatives have been with regard to their use of language. So when California considered Proposition 209 in 1996, an initiative that had a devastating effect with regard to diversity in universities, UCLA and Berkeley, devastating effect with regard to diversity in employment and contracting. It was called, and I'm quoting, the California Civil Rights Initiative.
Yeah, that's the point.
Well, I think progressives need to be much better about doing that. I'm just skeptical that fighting over the use of the word originalism is going to do that. To use your word, I think it has been overdetermined. I think what we need to explain to people is what constitutional law is and always has been. It's about value choices. Conservatives know that. That's why they fought so hard for Brett Kavanaugh. Progressives need to accept this, but then what we need to say is, this is what's our progressive vision of the Constitution, and what it's consistent with the Constitution's always meant to be about.
So ready up with your own questions. I'm going to ask two more, then stop. So one is in relationship to affirmative action. I mean, I don't know that people understand how affirmative action came into be and the extent to which it really was this compromise. So the way affirmative action is now constitutionally processed is it's under a strict scrutiny regime, by which I mean affirmative action occupies the same place that Jim Crow occupies in a way. It's treated as a use of race that we should be suspicious about. And in the context of deciding the constitutionality of affirmative action, the idea is diversity is the only rationale, not compensating for past inequalities or dealing with underrepresentation. I mean, should we be thinking about other ways to normatively defend affirmative action outside of the diversity rationale? Or do we give up because those other rationales, like, again, societal discrimination or underrepresentation, those don't have constitutional traction? Should we give up on them?
No, we shouldn't give up. Yes, we should defend them. In 1978, in a case called Regents University of California versus Bakke, 5 justices disapproved of the University of California, Davis, setting aside slots in its medical school program for minority students. But 5 said diversity is a compelling interest, or at least pivotal votes said diversity is a compelling interest, and that race could be used as one of many factors to achieve diversity. And so it's been for the last 40 years that it's thought that the only justification that's constitutionally acceptable for an affirmative action program is enhancing diversity. And what we lose with regard to that is the importance of engaging in affirmative action to remedy a long history of past discrimination and continuing discrimination. I present the statistics in the book about the difference right now today in terms of the percentage of children living below the poverty line, in terms of the numbers of African American, Latino children being about double the number of white children living below the poverty line. We could talk about the tremendous disparity in funding of public schools for African Americans and Latinos compared to white children. Well, when you put all of this together, you see why we need to have remedies today, and they need to be race-conscious remedies. It's the Supreme Court that's closed that door, that's prevented that kind of argument, and I agree we should reclaim it.
So my final question, and then again, ready up for your own. How should we be thinking about the Constitution and immigration? I mean, there one sees an awful lot of executive power. Are there checks on that, do you think? And the question, again, about the relationship between state governments and the federal government on immigration. There's huge battles now about where one might see states moving in ways that is not perceived to be preempted by federal authority.
Let me take the last part of your question and then go to the former part. And it'll go back to what I was saying about the irony of conservatives now being against states' rights. On January 26, 2017, 6 days after taking office, President Trump issued an executive order that state and local governments that don't cooperate with federal immigration officials will lose their federal funding. In the summer of 2017, Attorney General Jeff Sessions announced a policy that local governments that don't cooperate with federal immigration officials will lose federal law enforcement funds. There's all sorts of really good reasons why local governments don't want to cooperate with federal immigration officials. Los Angeles adopted a policy decades ago when Daryl Gates, the conservatives police chief, that the Los Angeles Police Department's generally not going to turn over information to immigration officials. The reason for this is that victims of crime, witnesses to crime, won't come forward to the police if they fear being deported. People who are sick, including with communicable diseases, won't go to public hospitals for treatment if they fear that's going to lead to their being deported. Parents aren't going to let their kids go to the public school if they fear that it's going to lead to the family being deported. And so that's why local governments have said they don't want to cooperate with federal immigration officials. To this point, 3 federal district courts, trial courts in San Francisco, Chicago, and Philadelphia, have said that the local governments have the right to not cooperate with federal immigration officials. 2 federal courts of appeals have upheld that. It's surely going to go to the Supreme Court, and it's going to be a tension for the Roberts Court between its conservative desire to protect states' rights and, on the other hand, its desire to defer to the president when it comes to policies of immigration. I hope that the conservatives will be consistent to conservative ideology and say states' rights. I'm skeptical.
When we want conservatism, we might not get it, it turns out. So questions, there are mics floating around. So who has a mic?
Weren't those magnificent questions? Yeah. Thank you so much.
No, thank you. So I'll let you just roll around.
Hi there. Thanks for the great discussion. My conversation concerns political parties. During the Constitutional Convention, we first saw America get a taste of partisan politics, and I guess that was later institutionalized by the role of political parties. As you know, the Constitution does not explicitly mention parties, and we've seen more recently with cases like Bush v. Gore, Citizens United, having a great impact on political parties in our country. So my question is, with the progressive reading of the Constitution, is there a role for political parties? Should there be one?
Great question. The framers did not envision political parties. Again, as much as we want to venerate them today, they weren't omniscient, and they didn't see how quickly political parties would develop. James Madison in the Federalist Papers was very critical of the notion of political parties. In fact, the way the Constitution was written, the number 1 vote getter in the Electoral College would be president, and the number 2 vote getter would become vice president. Could you imagine Donald Trump as president and Hillary Clinton as vice president? Very quickly in American history, the 12th Amendment was ratified so as to change that, to take into account political parties. There are many ways in which the law helps to institutionalize the 2-party system. The way people get on the ballot, the way public funding is allocated in certain elections, very much preserves the two-party system. Maybe it's time to reconsider that. One of the things that I think has added to our polarization as a society is that the political parties are now ideologically defined in a way unlike ever before. That until relatively recently, you had the Democratic Party that included Southern Democrats who were very conservative. We can remember a time when there was such a thing as a liberal Republican, an Edward Brooke from Massachusetts, a Jacob Javits from New York, a John Lindsay in New York, Nelson Rockefeller. There is no liberal. I mean, when you're thinking of Susan Collins as the most liberal person of the Republican Party of the United States Senate, you realize there's no such thing as a liberal Republican. Well, I think that the ideological definition of the parties may be very troubling, and maybe then it would be time to rethink the things that keep us being a two-party country, and perhaps it would be better to have many more parties develop in the future.
Other questions? Who's got the mic?
Thank you so much for the discussion, and I've heard you speak before, and so it's an honor to be here.
Oh, thank you.
I wanted to ask two questions. One was with respects to affirmative action. If economic disparity encapsulates the race disparity, why not base the argument on economic disparity? And the second question is, how can we use business? I live in San Francisco, and so being in the bubble of San Francisco, how can we use business or corporate America for change or to drive or enforce constitutional rights in different states?
As to the first question, what institutions learned after Proposition 209 is that affirmative action on the basis of social and economic class won't yield racial diversity. And the reason for that is the percentage of African Americans and Latinos who are disadvantaged is much greater than the percentage of whites who are disadvantaged. But the sheer number of whites who are economically disadvantaged is much greater than the number of African Americans and Latinos who are disadvantaged. So if you engage in affirmative action on the basis of economic disadvantage, you're not going to yield racial diversity from that. And law schools that tried to use economic disadvantage instead of racial disadvantage realized that wasn't yielding racial diversity. The second is a great question, and I don't have a good answer to it. But I'll point to one thing we need to think about. As I'm sure you know, the Constitution and things like freedom of speech apply only to the government. Private institutions don't have to comply with the Constitution. But now we look at private institutions like Facebook, Google, YouTube, that have so much control over the information we receive. How should we deal with that reality with regard to private institutions? And I don't have a good answer, but I think it is going to be the most important set of issues with regard to free speech going forward.
A couple more questions. Just again, travel with the mic. Dish out the mic.
Is there somebody here?
Someone has a mic? Okay, got it.
So the judicial branch is supposed to be the less political branch. And I'm just wondering, is there any way that you can think of that the Supreme Court would become less politicized? And do we even want that?
And Erwin, as you answer that, because
Sure.
in your book, you're very careful to draw a distinction between value-laden interpretations
Yes.
and raw politics.
Right. Yes, and let me use that as the beginning part of answering your question, then I'll deal with the latter part of the question. In one sense, the Supreme Court is not political. We don't elect the justices. They never face electoral review. You can't go and lobby a justice. You can go lobby your city council representative, your state legislator, your member of Congress, and it's absolutely fine. But no one can ever lobby a Supreme Court justice. So far as we know, the justices don't engage in vote trading, whereas we accept in a legislature there can be vote trading. So in this sense, it's not political. If what we mean by political is that the decisions are based on the ideology of who's there, that seems to me inevitable. And that's what I was trying to say now, that there's no way to avoid making value choices and interpreting the Constitution. I'd like to see us decrease the politicization of the judicial confirmation process. And I have a proposal for doing so, and it's beyond the scope of this book. I'd like to see the next president, Democrat or Republican, say, I'm going to appoint a merit selection committee with regard to the Supreme Court, and do it for the federal courts of appeals as well. I'm going to make 60% of the members of it from my political party and 40% from the other political party. And I'm going to ask them to send me 3 names that 75% of them can agree to. And I promise to pick either one of those 3 names or ask for somebody else. In that way, it would be somebody who comes in with bipartisan support, who's really picked for having outstanding credentials. And I think in this way, we can decrease the toxicity that surrounded the confirmation process this fall, at the time of Merrick Garland's nomination, and really for the last few decades.
We'll take a couple more questions.
Yeah, hi. This is kind of a 2-part question. The law is based largely on precedent, is it not? When students go through law schools, I mean, they're taught to appreciate precedent. Does that mean that there is really nothing new under the sun in terms of crazy legal strategies, something that would, for instance, get conservatives to argue against states' rights? And the second part of the question is, when you were talking about voter suppression, imagine for one moment that the state of California passed a law that, a voter suppression law that had the effect of disenfranchising primarily white Christian males. How long would it be until conservative lawyers were in court arguing that that law was unconstitutional? And could not that law, the decision in that trial, in that proceeding, eventually lead to the dismantling of all voter suppression laws?
Wait, just to be clear. So you're advocating some strategy to get... carry on, Erwin.
Yes, the American legal system, called a common law legal system, is based on precedent. And yet, on the other hand, there's long articles and books written about precedent, and they always come to the same conclusion. Precedent should be followed, except when it should be overruled. And of course, that's right. We all believe precedent is important for stability in the law, but we also believe there's times that precedent has to be overruled. Brown versus Board of Education was essential in overruling Plessy versus Ferguson. And the conservatives on the Roberts Court have no hesitation in overruling precedent. I could tell you about the couple of instances they did last term. But to then go where you did in the latter part of the first aspect of your question, there's the challenge for progressive lawyers to try to come up with new ways of presenting arguments to the court. This may be more complicated than it's worth in a short amount of time. The case that I'm arguing in the Supreme Court the first week of January involves whether the Supreme Court should overrule a precedent from 1979, Nevada versus Hall, that allows a state to be sued in another state's court. And this issue was before the Supreme Court in 2016, and the justices split 4-4. In fact, this case was in the Supreme Court, and the justice split 4-4. And I read all of the briefs from back in 2016 and how they presented the arguments, and I was trying to think, is there some new way to present this to appeal to conservatives? And I had an aha moment. I said, why don't I present this as a states' rights case? That it's about the power of a state to define the jurisdiction of its courts and provide a remedy for its own citizens when they're injured. That this is then, in the language of the Constitution, a 10th Amendment case. Now, I don't know whether I'm going to win. My brief's just been filed. But at least I've tried to present my argument using the conservative rhetoric and the conservative commitment to the 10th Amendment and states' rights. I think that progressives, given what the Supreme Court is now and it's going to be for a while, are going to need to think of ways to do that. Sometimes it'll work, sometimes it won't work.
I take it you're not advocating then the other strategy of some voter suppression law for white Christian males.
I'm never advocating voter suppression law.
We'll take one more question if we have it. So we have a lot of hands, so I'm glad I'm not doing the picking.
Professor Chemerinsky, Some time ago, you wrote an editorial in the LA Times advocating shorter terms for Supreme Court judges. But I don't remember what the mechanism of achieving those shorter terms was going to be, because the guys on there now are going to poison the lives of actually 3 generations of women. So is there a mechanism without a constitutional amendment, or does it require a constitutional amendment?
I'm going to separate your question into 2 parts. One is, one thing that will need to be thought of is expanding the size of the Supreme Court. The number of justices is set by statute, not by the Constitution. And I think if the Democrats take the presidency in 2020 and Congress in 2020, they should truly think about adding a couple of seats to the Supreme Court, saying that this is the remedy for the stolen seat that occurred with regard to Merrick Garland. There's a danger. We have to recognize that if the Republicans take the president and Congress in 2024, they'll add 2 more seats, and this could keep going. Also, I think that progressives should be very cautious about talking about this before 2020, because what would be more of a rallying cry for Republicans than the Democrats will increase the size of the Supreme Court? The other aspect of your question concerns term limits for Supreme Court justices. I've come to believe in them. Thankfully, life expectancy is a lot longer today than it was in 1787. Clarence Thomas was 43 years old when he was confirmed in 1991. Elena Kagan was 50 when she was confirmed. John Roberts was 50. Neil Gorsuch was 49. If, say, Clarence Thomas stays on the court until he's 90, the age at which John Paul Stevens retired, he'll be a justice for 47 years. If Elena Kagan stays till she's 90, she'll be there 40 years. That's too much power in a single person's hands for too long a period of time. Too much now turns on the accident of history when vacancies occur. Richard Nixon got 4 vacancies in his first 2 years as president. Donald Trump has had 2 in his first 2 years as president. Jimmy Carter got none in his 4 years as president. 18-year non-renewable terms would mean that every president would get to fill vacancy every 2 years. But I think it would take a constitutional amendment. Even if it happens, it wouldn't change those who are on the court right now.
So, Erwin, this has been incredibly exciting, promising, provocative. I want to ask you one more question before we go, which is this. You've said that by and large, constitutional law scholars, thinkers, etc., have not taken the preamble seriously. So what do you think our colleagues will say about this particular move on your part across the ideological spectrum?
I don't think the criticism will be at looking at the preamble. I think the criticism will be where I want to take the preamble. I think that there'll be 2 responses. One is dream on. The other is the originalist critique that this is just you reading your values into the Constitution, and we conservatives have a neutral methodology and we just go where it takes us. And so I think that we will play that debate out.
Fair enough. Well, join me in thanking Erwin for his terrific text. And there is a reception, I understand, outside, and there will be book signing. So thank you all very much for coming. Cheers.
Thank you so much. You're wonderful.
Oh, this is great.
Thank you. I'm so grateful.